retirement, all of those different things, I just like to call that your stuff. So that's one of the things that you have. You have your stuff. The other thing that you have is your person, care, treatment, dealing with doctors, dealing with procedures, dealing with facilities, all of the things that have to do with your body. So really, I can take what you've got, I can take what any client has and comes in to talk to me about and say, I just want to talk about your body and your stuff. Now, when people come to see me, there are two different time periods that I want to talk to them about. A lot of people come to see me about a will, and a will is something that happens when you die. So that's one end of the spectrum, when you pass away. I've got to change my presentation and make sure I stay in frame, because if I go like this, you're not going to know what I'm talking about. So one time period is after you die, and that's what a will is going to deal with, and I'll talk about that. But the other time period is from now until you die. So really, when I talk with clients, when I talk with people, I look at four different things. I look at your body before you die, your body after you die, your stuff before you die, and your stuff after you die. So those are the four different things that I can help people with, and they're really the four things I want to talk with you guys about today. Of those four different things, the quickest discussion that I have with people is talking about your body after you die. Now, the reason, there's a couple reasons why that's a quick discussion. First of all, it's none of my business. It's really very few people's business what your wishes are. And if we ever get to a point where we probate your will, and I'll talk about that in a few minutes, the will becomes a public document, and there's really no need for there to be a public dissertation of what your wishes are. Having said that, there's also a practical reason, and the practical reason that I see is a timing kind of thing. I've had clients die on a Friday, their family cremates them on a Monday morning, and on Wednesday they read the will, and the will says, whatever you do, don't cremate me. Well, at that point, we've got a little bit of an issue. So it's important that you know what you want. It's important that you tell your families. Now, with a married couple, a lot of times I will, one spouse tells the other, and that's great. And then if one spouse passes, the other one can make the arrangements. But the important thing to me is that you make sure the next generation or the next group or another group, some other people have the ability to know what your wishes are and then go out and carry out those wishes. I'm not opposed to, like it matters if I'm opposed or not. I'm okay with writing something down. That's fine. But don't put it in the will. That's really the last place that it needs to be. Put it somewhere that people know, oh, Russ died. Where do we go? Oh, we go into this thing and we look and, oh, there are his wishes. You can, if you want to, go to a funeral home and plan ahead of time. I recommend that to some of my clients. And some other clients, I'll recommend to go to the funeral home, make the plans, get a bill, pay the bill. Then everything is taken care of. Your wishes are going to be followed. It's going to get paid for, and it's something your family doesn't have to worry about. Now, something that I have had some clients ask, and it's been across all different areas of kinds of people, are, well, I want to donate my body to science, or I absolutely don't want to donate my body to science. The surrogate court clerk used to have a cartoon, that shoe cartoon, the birds up in the trees. The cartoon said, I donated my body to science, and now science is contesting the will. That's how I've always felt. Excuse me. If people have asked about that, and I've had some clients that are very interested in the treatment, the research of particular diseases or illnesses or conditions. In order to be donated to science, you've actually got to go through a process ahead of time. And if anybody has questions about that, I'd be happy to talk about it later on. Around here, Strong is the primary place that you would go. Don't worry about, it accidentally happening. So that's dealing with your body after you pass away. The most important thing, and something I want to spend some time talking about right now, is being able to deal with your body while you are still alive. Now, the first statement, the first thing I've got to say here is that our whole country is founded on the concept of self-determination. That's probably what a history teacher would call it. My kids would have called it, you're not the boss of me. And what I mean by that is the law says that every person over the age of 18 is the only person that has any authority to talk to a healthcare provider about how to treat, how to deal with, how to handle their body. And that's great. I love that concept. And it's a very important thing to have in play is the ability that other people can't make decisions about you. But there is a problem when you lose the ability to communicate with your healthcare providers. The cool thing about your body is you're always with your body. So if a healthcare provider has a question about, what do you think? What do you want? What are your beliefs? What are your wishes? Here's what you've got. Here's what we can do to treat you. Here are what the side effects are and things like that. They're going to go to you first because you're right there. You're the one they're working on. You're the one you're treating. If you are conscious and competent and able to meaningfully participate in the discussion, then you're going to. And that's what a doctor or other healthcare provider is looking for, is a meaningful exchange between their assessment of your condition and your wishes and beliefs and thoughts on your own treatment. The problem turns into what happens if you lose the ability to effectively participate in the process. And that can be for a lot of different reasons. It could be because you have a cognitive impairment. It could be because you've developed some kind of a dementia illness. It could be because you slipped in the shower and you whacked your head and you're unconscious. It could be many different reasons, but the end result is what happens when you're in a situation where you are unable to participate in your own healthcare decision-making. We have a problem. The reason that we have a problem is there's no law that says, oh, Russ can't do it. We'll just go ask his wife. She'll tell us what to do. Oh, Russ isn't married. We'll ask his kids. Oh, we'll ask his parents. There's nothing built in there that says, if he can't do it, talk to somebody else. If she's unable to participate, then you go to these people over here. What we utilize is a document called a healthcare proxy, and I'm sure a lot of you have heard of them. Healthcare proxy, in my opinion, is a terrible name because in my mind, healthcare proxy sounds to me like you're voting shares of Blue Cross Blue Shield. Bad name, but that's what it sounds like. Other states call it a healthcare power of attorney. You may hear the expression advanced directive. I don't care what you call it, as long as we talk about it and as long as it's something that you've got. So the purpose of a healthcare proxy is to enable an individual to appoint another individual to be the person to communicate to your healthcare providers when you're not able to do that yourself. Now, some people have said to me, Russ, I want you to name my 3 kids and they'll be my agent. Whatever they want is what I want my doctor to do. All right, we don't do it like that. What we do is we say, this is my number 1 agent. If you can't get a hold of number 1, I want you to talk to number 2. And if you can't get a hold of number 2, you talk to number 3. There's nothing that says number 1 can't talk to number 2 and number 3 and kind of reach a consensus. But if you look at it from a healthcare provider's standpoint, it's important that they've got a person to go to. And the issues that I've seen over my 27 plus years of practice and my involvement on ethics committees and in other situations have been when one person in the family says, do this, and the other person in the family says, don't do that, do this instead. So the first thing I want to talk about with a healthcare proxy is a healthcare proxy. I think it's mandatory. Once you turn 18, you should have one, and it's going to be somebody, this is the person I want you to talk to. If you can't get this one, talk to this one, and we'll go all the way down the page. I mean, I got stacks of paper I can put in my printer, and we'll make it as long as we have to, but I want there to be a lot of different agents. Now, another couple things about who you appoint as the agent. I have had people say to me, look, my daughter's a doctor. I'll name my daughter the healthcare agent. My son's a CPA. I'll name my son the power of attorney. Okay, I'm going to talk about the power of attorney in a minute. That's not the right idea. The concept, what I want you guys thinking about, what I want anybody thinking about is who knows what my thoughts and wishes are, and who's going to talk to the doctor and be able to tell the doctor what I would think, what I have expressed to them, what my beliefs are. I had a client, a couple one time, they were probably in their late 80s, and the husband said to me, Russ, I know what my wife's wishes are. She would not want to be kept alive unnecessarily. She would want me to pull the plug. I could never do that, no matter what the situation is. I can't think of a situation where I could tell the doctor to pull the plug. His wife said, oh, honey, that's cute. I'd pull the plug on you tomorrow if I could. But we decided in that case, look, if you name your wife as your agent, then it's very possible that your wishes are not going to be communicated. So the purpose here is to have a vehicle, a method for your wishes to be communicated. So you got to pick a person that you are confident has an idea of what those wishes are and will be able to communicate to your providers, hey, this is what Russ would have wanted. Now, some people will ask or say to me, look, I don't want to make decisions. Decision making is a very difficult thing. I agree with that. So I try to sell it. I say, look, your agent is not making decisions for you. Your agent's job is to communicate to the team what you think, what you would want, what your beliefs and what your wishes are. So the decisions will be made as part of a team, the doctors, the treatment team, whatever, with an understanding or a communication of what those beliefs or wishes are. So some people say, I don't want to make a decision for my dad. That's too hard a thing. I'll say, listen, you may not be making a decision. You're just expressing wishes. Other things that people will ask me, well, you know, my husband would be fine as a first agent, but my daughter lives in Boston, my son lives in DC, and our other son lives in Seattle. I don't care. Pretty much everybody's got one of these things now. And from a healthcare standpoint, the treatment team is looking for somebody to tell them what to do. They're dying for help. They are very much in favor of having an agent, and they'll talk on the phone. Okay, so don't worry about physical proximity when you're selecting a healthcare agent. Worry about picking people that are aware of your wishes and are confident, both you and that person are confident in their ability to express those wishes. Okay. The healthcare proxy that I use also has as part of it what's called a living will. Now, I'll give you a real quick history lesson. The living will actually came before the healthcare proxy. Back in the early 70s, there were a couple different cases. There was one down in Texas, and the one that I always remember was a New Jersey case. There was a young woman named Ann Quinlan. She had an illness. She OD'd on heroin, and she was brain dead, and she was unconscious. And the only thing keeping her alive were machines. So her family, said to the hospital, we don't want her kept alive on machines. The hospital said, we aren't in the business of killing people. We're in the business of saving people, and we can save her by keeping her plugged in, so we're going to keep her plugged in. Long story bearable, there was a lawsuit, and the court came out, and it actually went to the Supreme Court of the United States. The decision was that people, the people in the United States, citizens, have the right to either withhold or withdraw life-sustaining treatment. What they said was, in these particular cases, it's unfortunate that they didn't write down what their wishes were. It's too bad they didn't have a living will. So that's what a living will was. So everybody at that point starts doing living wills. And a living will is a statement that says, if I am terminally ill, or if I'm permanently unconscious, or if I lose there's no reasonable expectation of my recovery, then these are what my wishes are. Great. Problem is, healthcare decisions are not only made in end-of-life situations. They're also made in day-to-day situations. Go back to where I slipped in the shower and whacked my head, and I'm unconscious, but when I fell down, I broke my wrist. So with my broken wrist, now the doctors are going to say to me, hey, we're going to put a cast on your wrist. What's your favorite color? Well, I kind of like blue. I'm unconscious, so they can't ask me things like that. There are ordinary day-to-day healthcare decision-making questions that can come up without it being an end-of-life situation. So the living will is not the be all and end all of documents that enable somebody to talk on my behalf. So we tried to modify the living will, and we'd say, you know, if I'm in an end of life situation, here's what I want. And if I'm at a non-end of life situation, talk to this guy over here. Well, legislatures, like they usually do, decided to get involved. And at that point, they came out with a healthcare proxy. And a healthcare proxy, or a healthcare power of attorney, does what I just told you it does. It enables somebody else to talk for you. Now we got healthcare proxies. Fantastic. I love it. I need my wife to make decisions for me. I have a situation where I'm now in a hospital. They talk to my wife. She tells them what I want. And then it gets to a point where I am in an end of life decision making situation. And the healthcare provider says, all right, Russ's wife, Heather, and her name's Heather, you know, what would he want? And she says, well, he has told me time after time he doesn't want to be hooked up to machines, so go ahead and pull the plug. And then the hospital says, oh man, that's just too bad he never wrote that down anywhere. So we started with we started with nothing. We had the living will. After the living will, we ended up with just the healthcare proxy. Now we've got them together. Now somebody out there in this group of 27 people is going to say, I don't need a healthcare proxy, or there's something new, and it's called a MOLST. And I'm going to agree with you, there is something new. New is a relative term, because I think a MOLST has probably been around for a little over 10 years. A MOLST, let me describe that. And it's different. I'll give away the end of my story. It's different than a healthcare proxy, but they work together. MOLST is something that stands for Medical Order of Life-Sustaining Treatment. It is something that comes into play when you are being treated and the possibility of an end-of-life situation is there. Now, there's a couple of really cool things about a MOLST. The first cool thing about the MOLST is it is this bright, hot pink color. It pops. You can't miss it. If you can see my office is a mess. If there was a MOLST lying back there, anybody could see it. I love it because if somebody is looking for it in the hospital, bright hot pink is easy to find, and they're gonna see it right away. Except now everybody uses electronic medical charts, so it doesn't pop out of the chart the way that I think they originally intended to. It's also this really thick stock cardboard stuff. And so again, if it was in an actual chart, it's easy to find. The best thing I can say is at least that bright hot pink is going to look good on your refrigerator at home in case you come home from a facility with one. The other thing about a MOLST is the doctors came up with that. All right. Now, granted, they probably had help with, you know, corporate counsel, but there have been good-natured rivalry between doctors and lawyers all the way back to before my professional ancestors were drafting the Constitution of the United States, and doctors' professional ancestors were treating people with leeches. But I don't want to get too deep into the doctors. The cool thing is I want my clients to have the treatment and the care that they want. And doctors will have recognized, and they really like this form. And so the MOLST is something, if you're ever in a situation where it is filled out, it works. It is a great expression of what your wishes are. The cool thing about it, another cool thing about it, is if you are unable to talk to your doctor while you fill it out, your healthcare agent can be the one to talk to your doctor while you fill it out. Another really good thing about the MOLST, another way to think of the MOLST is it's the next generation DNR. If anybody has heard of the DNR order, which stands for Do Not Resuscitate, this is kind of, it encompasses that concept, but it's how do we treat this person in an end-of-life situation. So another thing that I like about this MOLST is it's what they call portable. And by portable, I mean it's supposed to follow you wherever you are. So you're in the hospital and you're in ICU and they fill out this MOLST. Then from the ICU, you go to the floor, and on the floor, the MOLST follows you, and it is still a viable order regarding your care. And then from the floor, you go home. It still follows you, and that's where you take it and you stick it up on your refrigerator and do stuff like that. Or you go from ICU and then you end up on the floor, then you go to the nursing home. And you're in the nursing home and you have a MOLST, and then you get pneumonia or something else, and you end up back in the emergency department. What has happened in the past is I have had clients in a nursing home at the end stages of an illness develop some kind of a chronic disease or acute disease, go to the emergency room, and then the emergency room cures them, or the hospital, and then they send them back to the nursing home, and they're right back where they were. And somebody says, well, why the heck is this person even back here? Didn't you see the DNR order? Didn't you see the whatever? And the answer is no, they probably didn't, because it didn't follow. So part of the intent when this form was originally created was the ability to the ability to make a statement and then have that statement follow you. So if somebody says, do you have a healthcare proxy? No, I don't. Well, do you have a MOLST? Yes, I do. Okay, then you're fine. No, you're not. I mean, you're okay, but let's work on getting a healthcare proxy and the living will together, and then a MOLST. And a MOLST is situational. The MOLST is only going to be in the circumstances where, you know, it's an end of life type of situation. Okay. The reason, why the heck am I talking about this stuff? Well, I'm talking about this not just based on, you know, the fact that I'm talking to the Parkinson's Wellness Recovery Group or the Parkinson's group, but I'm talking to everybody. Everybody should have the ability to control, to dictate, to direct who's going to be helping you with medical decision-making down the road if you're not able to. Okay, so whether you have a diagnosis of, you know, a positive diagnosis of something that you know is going to affect you, or if, you know, you just recognize that life is full of uncertainties, these things that I'm talking about are very important to me. Now, when we do a healthcare proxy, and I'll tell you, you can get one online. You can go to the New York State Department of Health website and download a healthcare proxy. The difference between that healthcare proxy and my healthcare proxy is they have a healthcare proxy. Then you can get a living will, and you could do those two different documents. I do the two documents together. The other difference is when I do a healthcare proxy, I help you execute it. If you download one online, you may not have the help of someone to execute it. And I have seen situations where, let's say I name Pat and Mike to be my agents, and then I have Pat and Mike witness it for me. It's not any good at that point, you know, so you've got to just think about things. Now, if you go to a hospital, they have forms and they'll help you fill it out. If you're at a place like, you know, a senior living or a congregate living area, they'll help you fill it out. I just want you to have one, and making sure that it's filled out correctly is fantastic, and it's important, and it's great to have, and you got to have it, because at the end of the day, having the ability to direct and participate in your healthcare is the number one thing, in my opinion. What happens if you don't have one? Well, a couple different things. Thankfully, within the last 7 or 8 years, there has been a law passed in New York that permits, in end-of-life situations, the provider of care to talk to a delineated group of family members. Hey, Russ is not going to come out of this. What do you think he would want? Thank God for that, because if you don't have something like that, the only remedy is to have a guardianship proceeding where you are declared judicially incompetent by a judge after a public proceeding, dragging all of your business through open court, which may or may not be open based on COVID, but the concept is still the same. And it's very expensive, and it's going to take 30 to 60 days. It's going to cost at least $15,000 to do something like this. And you can go to Google and do healthcare proxy, New York State DOH, and be done with it. So that's pretty important. If you go into a facility, there is a law that says you have to be asked if you have advanced directives. They are supposed to ask you, do you have a healthcare proxy? And if you do, great. If you don't, they should be able to give you one and help you fill it out. The social workers in this whole region, fantastic people, and they'll do everything they can to help you out. When you do a healthcare proxy, what should you do with it? I want you to take one to your primary care doctor. I want you to take one to every specialist that you might have. Take one to your dentist if you want to. Take one anytime you're going into a facility for a procedure. You're going to have your tonsils out next Friday, take a copy in with you. If you're going to have a pre-op appointment on Wednesday for a procedure on Friday, take it in with you on Wednesday. Take it again on Friday. I don't care. Get the darn thing into the computer so that anytime they look you up, it's there. Now, I had a client tell me about a week ago, hey, what if can I upload it to my, my patient record online? I don't know, I said. That's a great question. Well, I found out the answer is yes, but I don't know how yet. I'm working on it. If you come back and see me in about a week, I'll be able to let you know. But just take it to your doctor. Let your agents know. Hey, Timmy, I picked you, and there's a copy of my healthcare proxy in the cupboard, in the kitchen, in the drawer, in the desk in the kitchen. And if something happens, go to it, okay? And get it out there. Wallpaper the world with it. Tattoo it on your chest if you want to. I'll give you a little card that says, I have a healthcare proxy. Call Russ at 1-800-COOL-GUY, and we'll get it to you. Got to have it. That's pretty much the bottom line. And out of everything that I want to talk about, that's the most important thing. Now, somebody asks a question about what about donating your body to science? What if you change your mind? Well, you always got the right to change your mind. And mainly, I will advise clients to try to leave things as open-ended as you can. And what I mean by that is, instead of having the documentation say, I give Russ the authority to decide whether or not to donate my body to Strong Memorial Hospital for the med students to use for blah, 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 blah. Just use a healthcare proxy that says, I give Russ the authority to make any decisions for me, dead or alive. You change your mind about what you want, then you tell Russ, and I'm not going to be your healthcare agent, okay? But you tell whoever you pick as your agent what your change is. If you have gone so far as to go too strong and you're actually in one of those programs where you're going to donate your body to science, you have to affirmatively take an action to get into that program. So you would have to affirmatively take action to get out of that program. If you said to your agent, listen, I'm signed up to, and I got a great joke. So let's say, well, it's a joke. I'll let you guys decide if it's great or not. When you go through this program and you say to Strong, I want to donate my body to science, they can always say, thanks very much, but we don't want you for a couple of different reasons. So that gives you a chance of having applied to the U of R after high school and getting rejected for college, having applied to the U of R for graduate school and getting rejected from graduate school, and they might reject you after you die. So you could really get rejected by the U of R by at least 3 different circumstances. What the heck, go for the trifecta. So if you change your mind, when you are able to change your mind, do something about it today. Don't wait. Oh, it can happen tomorrow. It can happen tomorrow. It can happen tomorrow. All right, so that's all the questions that I see so far in the chat. I want to move away from your body and start talking about your stuff. But before I do that, does anybody want to ask any questions about this stuff I've been chatting about? And I'll take that as a no. Does someone need a most? Okay.
Does someone need a most? MOLST, is that the correct spelling?
It is. It's an acronym, Medical Order Life Sustaining Treatment.
Okay.
You don't need one unless your treatment team thinks you need one. It's only in end-of-life situations, and you don't fill it out, your doctor does. So most of the time, or all of the time, if you need one, they'll tell you that you need one, and they'll, by they, I mean, your medical providers, they'll fill it out with you.
Okay.
If you are unable to do so, your healthcare agent can fill it out, can answer the questions and fill it out on your behalf.
Okay.
All right?
Mm-hmm.
Any other body questions?
Yeah,
All right.
Russ.
Yes.
Yeah, this is Norm Schrader. Right now, I'm blanked out, but I have the audio on. We just went through this a few weeks ago. Now we had a will previous. We got our healthcare proxy taken care of with our daughter. She's the representative, and our youngest son is our secondary. But when we got to the power of attorney, they had the two questions. One is, you just want to give her power of attorney, or do you want it to be where two doctors have to certify it before you can do it? And that's the way we went. Not necessarily that we don't trust our daughter, but she's already been hacked a few times online and things, so we wanted to make sure that it was actually what we wanted and not somebody hacking in on it. Does that sound legit?
I'm going to answer your question like this. You're stealing my thunder. I'm going to talk about that in just a second. So what you're talking about is what we call a springing power of attorney. I've written it down so I don't forget, but when I do forget, just holler out, hey, you were going to answer my question for me. So let me jump into that. And what we're talking about with a power of attorney is your stuff. We're done with your body. We're going to talk about your stuff now. So when we talk about dealing with your stuff while you're alive, which is, worth spending probably the rest of the time on this, there's a couple different ways that you can manage your stuff, your things, your assets. I'll give you an example. One way that you can manage some assets is based on the nature of the ownership of your assets. I have a joint bank account with my wife. My wife went out of town last summer, and a check came in the mail that was payable to her. So one of the things that I could have done with that check is to take that check and deposit it in our joint account. So I've got an asset that's her asset. It's a check payable to her. I put it into a joint account, which is an us asset. And then because it's in a joint account, which you can deposit without having anybody sign, I take it out and I make it a me asset. So I took something that was hers and I made it something that's mine just by utilizing this joint checking account that we have. Now, realistically, I forged her name on the back of the check, okay? And the statute of limitations is running that. I can't get into trouble. That's what most people do. But let me give you another situation. Let's say that I have a house that is jointly owned. And with that joint house, I go into a nursing home. And in the nursing home, very expensive, I want to have Medicaid pay for the nursing home. Well, Medicaid has decided that it's okay for my wife to have a house. I can't have a house, but my wife can have a house. Well, this house that we've got is owned jointly like this. We both own the whole house. I want to put it so that she owns the house. Well, if I'm competent, if I'm conscious, if I'm capable, I'll just sign a deed. Okay, that's easy. I'm going to transfer that house to my wife. If I am unable to sign, now remember, in my example, I'm in a nursing home. I am in a nursing home for a cognitive issue. I lack the ability to legally sign a deed. So what do I do? Well, that's where this power of attorney comes along. So the general concept for a power of attorney is it is my ability to appoint one or more people to do things regarding my property, my assets, my stuff, okay? So the general concept of a power of attorney is I appoint her to take care of my things. And when I started practicing law in the early 90s, it was one page long, and it said, I appoint her to do what I can do. It's 12 pages long now, unfortunately. And what's happened is The legislature, again, has gotten involved, and they've made it a little bit more involved, and they're trying to prevent there from being misuse of powers of attorney and for or do all of these things. And then I list out 5 pages of different things that they can do. Now, let's talk about a springing power of attorney. A power of attorney is a very, very powerful thing. Remember when I told you before that you're always with your body, but you're not always with your stuff. Okay, most people are not with all of their stuff right now. If you guys were in my office, I would say one of your biggest things is your house, and you're not in your house right now. I can't use that line because you guys are all sitting in your house, but you're not with your cars, you're not with your bank, you're not with your insurance company. The chance, the possibility of misuse exists without your knowledge if you're not with all of your things. So there is a little bit of fear, a little bit of concern, a little bit of let's be careful out there kind of an attitude. The most important thing that, or the best thing that I can do for you is to give as many different people as we can figure out every single power that you can imagine, so that when that 1 in a million thing does happen, we've planned for it, okay? The most dangerous thing I can do is give somebody the power to take away all your stuff and have them take away all your stuff. I want to give a lot of people the ability to rob you blind. I just don't want them to rob you blind, okay? So the way that the legislature has gotten around that is they have the agent sign a piece of paper that says, I understand that I have been given this great responsibility. I promise not to abuse it. I won't steal from it. I thought when I first saw that, that was the best idea I had ever seen. My suggestion was, let's go to high schools, and every senior class before they graduate just has to sign something that says, I won't break the law. And as soon as they do that, we're not going to need police officers anymore. We're not going to need judges anymore. So unfortunately, it doesn't always work. So the first thing is you got to have some confidence in the people that you pick. Now, the way that you were talking, and I'm pointing at you, but you can't tell because I'm pointing at a screen, but trust me, I'm pointing at you. The way that we used to deal with this is to create this thing that we call a springing power of attorney. A healthcare proxy is springing by the very nature that as long as you're able to talk to your doctor, they're going to ask you. But I could walk into the bank with your power of attorney, you could be perfectly competent, and I could say, hey, Pat wants me to take all of her money out of this account. And if everything's in line, they're going to go ahead and take it out, and that's cool. So people had a concern that if we're planning on using the power of attorney after somebody becomes unable to use it, let's make the power of attorney good only after they've become incapacitated. Pretty good idea, okay? But I don't like it. And in fact, the state has stopped making a statutory springing power of attorney. One of the reasons that I don't like it is that it requires 2 doctors to certify that you lack the ability to meaningfully manage your affairs, okay? And okay, I understand that, but that can be tough. I'm involved in a guardianship proceeding where for the last 6 weeks, I've been trying to get the second doctor to sign off on something. Doctors are busy. Sometimes it takes a while. So the reason I don't like it is not because I don't like doctors, not because I don't trust them, but it adds another wrinkle, it adds another delay or another step in the process. Another reason that I'm not a big fan of the concept is I'm not just planning for people's disability. I'm not trying to make it so that if you end up lacking the ability to do anything at all because of a physical, cognitive condition, then we can do stuff. I want to be able to manage your affairs for pretty much any reason. I'll give you an example. I have clients that go to Arizona in the wintertime. I had a client a couple months ago go to Arizona and something came up at the DMV. She's in Arizona. I'm in Canandaigua. I had her power of attorney, and I went to the DMV and I fixed the problem. That was great. She wasn't incapacitated. If it was a springing power of attorney, I would not have been able to get a doctor to certify that she lacked the ability to do things. So it's helpful. I will say again, yeah, there's some risk involved. I can't dispute that because there is. So what I end up advising my clients is I want you to pick as many people that you have a lot of confidence in and give them as many different powers as you can. Okay, so when New York State decided not to do the statutory springing power of attorney, what I have done to get around that, because some clients just want it, okay, they absolutely just want it. I draft a letter from my client to me, and the letter says, Russ, I just gave you my power of attorney. I don't want you to give it to anybody unless you get a letter from a doctor that says I've become incapacitated. I like my chances in trying to talk people into things, but there are sometimes I just can't talk people out of that concept. And in that situation, that's how I solve that concept. It is a difficult topic to talk about, but there is always a potential for a mistake or misuse or intentional malfeasance. I tell my clients, let's pick people that you trust. One client that I had, the only person he had any confidence in was his son. His son was 18. There's not a lot of 18-year-olds that are as sharp as they ought to be. So what we did in that case was we had him name his son, never told his son that he was a power of attorney, and then told his son, if there's a problem, go see Russ and he'll help you out. So you can absolutely set up a power of attorney so that it doesn't become effective until a date in the future. I will try to talk you out of it like I have for the last 5 minutes. The importance of the power of attorney is the ability to deal with as many different things regarding your resources, your assets, your income, your insurance, your property, your vehicles, all of your stuff, okay? I'm a big George Carlin fan, and he used to talk about a place for your stuff, and that's probably why I call it stuff. But I want to be able to deal with your stuff no matter why, and you gotta have it. Now, what else can you do? I could put my daughter on my bank account as an additional signer of my bank account. She doesn't need a power of attorney. She's authorized ahead of time to go ahead and sign for me. But it's difficult for me to authorize my daughter to sign a deed conveying my interest in the house without using a power of attorney. Maybe I can go to my insurance company and say, you know what, you can talk to my son, Alex, anytime you want to about my insurance, and that's cool. But then he calls and says, Dad just called me and said he wants to increase the deductible on our policy. And they're going to say, well, unless you've got power of attorney, we're not going to do that for you. A couple interesting things. The federal government, in spite of the Constitution, does not recognize the state's abilities to create a power of attorney. So if you have a New York State power of attorney or an Ohio power of attorney or whatever, and you try to use it with the IRS, they laugh at you and they say, we don't recognize your power of attorney. You have to use our power of attorney. I say, okay, do you mind if I fill that out using my power of attorney? And they're like, oh yeah, that's fine. Don't worry about it. You can use your own power of attorney to fill out our power of attorneys. Okay, whatever. Social Security. They don't even know how to spell power of attorney. The only thing they recognize is what's called a representative payee, which is cool because you get to put 2 E's on the end of a word, which makes it sound official. But it doesn't really do anything, but that's one of the things that you do. Now, I think the last thing I want to really focus on with a power of attorney is probably the most important part of a power of attorney. The law says you can't use a power of attorney to give away any more than $500 of one person's stuff, okay? So they could take my account and use the power of attorney and give away $500 to as many different people as they want to, 500 at a chunk, okay? That'd be about 5 people, but you know, $500. But if my house is joint and I want to take the interest of my interest in the house, give it to my wife, or we want to give it to our kids, house is worth more than $500. I can't do that unless you affirmatively acknowledge or affirmatively grant the power to the agent to make gifts. So New York has this thing that they call the statutory gift rider. And in essence, it says, I authorize my agent to give away stuff as much as they want, even to themselves. There are a lot of people that'll help you fill out a power of attorney, and when they see that gifting thing, their first comment is, oh my God, well, you don't want your kids to take all your stuff. You don't want to give away all your stuff. And you don't, unless you need to qualify for a nursing home. If I can transfer your house from the two of you to just your spouse, and you get to keep your house, that's a huge deal. So a lot of times when somebody says, don't worry about that gifting thing, you got to worry about the gifting thing. You got to fill out the gifting thing.
Now, I had
I
another
want you.
question about, if
Go
I
ahead.
could.
Go ahead.
We get into a situation that we had back in 2014. I was diagnosed with Parkinson's and was listed as disabled with Social Security. In 2016, my mom had a house in Rochester. It was all paid off in that, but it was determined she had to go to a nursing home. None of us could take care of them. So we went into our attorney's office, and the attorney that I had was part of the same firm that we went to, and we had an elder care lawyer there. And the attorney asked me, well, how are you been doing? I haven't seen you in a year or two. I said, well, came down with Parkinson's. I'm listed as disabled now, so I'm on disability. And he called the elder care attorney over, and he said everything just got easier because you can give your house to a son or a daughter or relative if they have a disability without consequence. And that's exactly what happened. Maybe you could explain that a little bit for the folks. But they gave me the house because I was legally disabled. And,
So there's in that whole discussion, I mean, that's a great point. That whole discussion is another hour or hour and a half. And talking about Medicaid, the first thing I'll tell you about Medicaid is everybody has a Medicaid story, and most of the time they're wrong. Now, your story is right, but when my cousin's uncle's best friend's girlfriend's sister's mom went through Medicaid in 1964, this is what they did. Now, the rules have changed a little bit. But the big thing with Medicaid is they want to know what your income is, they want to know what your assets are, and they want to know what you've given away. And income, it is what it is. There's very little we can do with that. Your assets, there are assets that Medicaid cares you have, and Medicaid does not care about other resources. They call them resources. And then they look at what you used to have. And they look at what you used to have for 60 months, 5 years. Okay, people, like every third person that comes in tells me, oh, they changed that. No, they haven't. It's still a 5-year look back period. What they're looking for is you having given something away. So if you give your house to your kids, that's a gift. If the house is worth $200,000, that's a $200,000 gift. Okay, so Medicaid is going to say, you gave that away. We have a problem with that. And then there's a consequence. If you give your house to your spouse, they don't care about that. So they don't care if you give something to a spouse. They also don't care if you give something to a disabled adult child, which would be the situation that you're talking about. They also don't care, and this is something I've used not as often as I would like to be able to use it, but they also will allow a gift to what they call an adult caregiver child. So I live in Seattle. I moved back home to Canandaigua to take care of my mom, and I'm there with my mom for 2-3 years. And because I'm at home and I am taking care of my mom and I am helping her with her activities of daily living, getting up and going and eating and taking her medicine and all that different stuff, because I'm helping her with that stuff, she's not in a nursing home. So in a case like that, Medicaid is going to let her transfer her house to me, and they're not going to penalize it for me. The thing that I want to focus on today is you can't do the things that I can help you do if you don't put into place the tools I need to do those things. So I may have the ability to transfer your house to your adult disabled child, or I may, a disabled child, doesn't have to be an adult. I may have the ability to transfer your house to an adult caregiver child. I may have the ability to transfer the house to your spouse. But if you haven't done a power of attorney, and if you are incapable of executing the documentation that I need you to execute, we have a problem. And the problem can only be solved in that situation, the guardianship proceeding, which is expensive and time consuming. I love it. I love doing guardianships because my kids have got to eat too, but you don't need, I'll make my money somewhere else. Get a healthcare proxy and get a power of attorney. Don't worry about doing a guardianship proceeding. That's not your plan. Your plan should not be, I'll let Judge Doran figure out who should take care of my stuff. Nah, I don't want Craig to be the one making that call. I want you guys to be the ones making that call. Okay.
Russ, I have a question on the power of attorney. You say they're issued by the state. What if I hold a power of attorney for a person and they move to Connecticut? Do I need to get a Connecticut power of attorney when they do that?
Great question. And let me just clarify, they're not issued by the state, but each state has what they call a statutory form. And the concept is, hey, if it looks like this, we're automatically okay with it. The state doesn't issue anything, but I do it. And the one that I do and that other people do is kind of been accepted by the state. But your question is a bigger and better question than that. And there's two answers. There's the legal answer, and then there's the practical answer. Okay, the legal answer is the 4th article of the U.S. Constitution says that each state shall apply full faith and credit to the laws of the other states. What does that mean? That means when you're driving to Florida and go through Pennsylvania, you don't need to stop and get a Pennsylvania driver's license because New York has licensed you. You are licensed in all 50 states to drive. It also means if you get married in Pennsylvania and you move to Massachusetts, if you were legally married in Pennsylvania, you are legally married in Massachusetts. It doesn't matter. An example here would be South Carolina allows common law marriage. New York does not. My wife and I lived together in South Carolina for 25 years. We told everybody that we were married. We weren't legally married. We weren't married by a church or a judge or anybody like that. But in South Carolina, they say if you live together for a certain period of time, call yourself Mr. and Mrs. Smith, you're married. Then we moved to New York. New York says, let's see your marriage certificate. I don't have one. Well, then why are you telling me you're married? Well, because I lived in South Carolina together and we represented ourselves to be husband and wife. They say, oh, okay, so you're married. That means that if I have a power of attorney that is valid in New York State, if it's properly executed in New York State, it is valid in Massachusetts, it's valid in Pennsylvania, it's valid in Ohio, it's valid anywhere, and even in Louisiana, okay? It's valid, it's legally valid. That's the legal answer. The practical answer is, how are you gonna get them to take it, okay? So a lot of times you're using a power of attorney with a bank teller, for example. Bank tellers, when they're kind of entry-level positions, they've had 5 minutes of training on what the heck a power of attorney is. They know what it looks like because it says State of Massachusetts Power of Attorney on it. And you bring one in that says this is a New York State statutory short form power of attorney. Well, that's not legal because it doesn't say Massachusetts on it. She's got to take it to the head teller. The head teller takes it to the branch manager. They call the corporate counsel. Eventually, somebody calls Russ and says, what the hell is this power of attorney you drafted in 2021 in Canandaigua, New York? They don't say Canandaigua correctly. And I can convince them after much arguing and yelling and screaming and gnawing of teeth, yeah, it works. Same thing with healthcare proxies. Or if you move to Tennessee, get a Tennessee power of attorney. If you've got the time, if you're able to do so. If you're trying to do something because you're on vacation and you got 5 minutes that you got to get this thing done, we'll argue the argument about whether New York is good in South Carolina or not. If you move somewhere else, get the new one. It's just that's That's the practical answer, okay? One of the things I do want to kind of point out is the thing I like about a healthcare proxy is that the provider wants to be told what to do. They love healthcare proxies. You do it on the back of a cocktail napkin, they're going to take it. Financial institutions, they don't want to give up your money and they don't want to get sued. They do everything they can to reject your powers of attorney. All right, fine. I'll take 5 extra minutes. I'll take an extra half a day to convince you that it'll work. Healthcare proxy, boom, boom, boom. Let's get me fixed right now. Okay. Any other, does your power of attorney need a card? Jose, Yvonne, what is your question?
You said something about to prove at the bank or whatever. Can you just take your living will or?
So that's a great question. What I said before was I can give you a little card that says I have a healthcare proxy. And that's something that I do sometimes. And it's just so that you can put it in your wallet. And if somebody finds it, they'll know where to find the healthcare proxy. Power of attorney, I don't usually do that. But what I would have you do is take the power of attorney to the bank now. Well, you are both able to talk to the people at the bank and say, we just had this power of attorney and we want you to have a record of it. Does it look okay? Do you have any questions? You don't need to have a card in any respect. What you might need, though, is a bank very likely will ask you for the original power of attorney. They don't need it. They are entitled to see it. What I usually do is I will give my clients a certified copy. That's a copy that I have made, and then I've got a special stamp that I put on it, and I sign it that says, I'm a lawyer, I've looked at this, it's exactly the same as the original. That way I keep the original in my office where it doesn't get lost in spite of the mess you see behind me. You know, those things go in my fireproof safe, and they're always there. So you don't, it's a very good question. My advice with the power of attorney is when you are able, get it to whoever you might use it with ahead of time so they can approve it instead of saying, well, you have to fax it to us and our legal department has to review it. And our legal department is only open on the 3rd Wednesday of every week and blah, 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 you know, so try to get it out there ahead of time.
Thank you.
Thanks.
I've officially run out of time, but I can still take any questions if anybody has any more questions. At the end of the day, my advice is try to take care of your body and your stuff ahead of time. And we have the ability to do that. I can go ahead and help you with those things. If you have questions, the internet is full of answers, but they're not always the right answers. Talk to your healthcare provider about healthcare proxies. Go ahead and talk to a lawyer, talk to a financial advisor if you want. Talk to somebody that you trust about the power of attorney piece. All right.
I have a question.
Yes.
Well, I appreciate all the information that you've given us today, but I would actually appreciate another session discussing trusts and when you need a trust and if you need a trust.
That's a great idea.
Mm-hmm.
That's a great idea. And I'd be happy to present on that topic. And
Because right now in our personal situation, we're at the point where we know nursing home is going to come sometime down the line, hopefully not within 5 years, but I want to be prepared for that and I have no idea where to start.
well, I'm sure the group can try to set something up for me or somebody like me to come back and talk.
Absolutely.
Yes,
Thank
I
you.
agree. I'd like to hear that as well.
Yeah, I think a lot of people would.
Russ, I have a question about the 5-year look back. As far as IRAs go, are all IRAs susceptible to a 5-year look back? Like is a Roth IRA the same as a simple IRA as far as the look back goes?
6 months ago, I would have said Roths and traditional IRAs are completely the same. 6 weeks ago, I would have had to tell you that Roths are treated differently than traditional IRAs. And then last Tuesday, I won that argument. So a Roth IRA is treated the same as a traditional IRA as long as you're getting payments out of the Roth IRA. So what happens is an IRA is looked at as an exempt resource. They don't care that you have it, but they're going to look at the income. You have to take the income out. Even if you're under, which now is 72 and a half, it used to be 70 and a half. If you're under the age where you're obligated to take it out, you can still take money out of an IRA, Roth or traditional, and they won't count the value of the IRA. They look at the income that it's generating. So if it's $12,000 a year, let's say you're taking $12,000 a year out, that's $1,000 a month. That's what they calculate. Now, the look back doesn't necessarily apply with an IRA because you can't really give away an IRA. You own it. It's your IRA, okay? And it's a lot of different law behind that. The only way you give away an IRA is when you die. It's inherited by somebody, and there's different rules, whether it's a spouse that inherits it or a non-spouse that inherits it, excuse me. So the easy answer is, as long as you are annuitizing or taking payments out of your IRA, traditional or Roth, they'll only look at the income, not the value of the IRA. Don't worry about look back with the IRA. Worry about whether you're taking payments or not. Okay. You could not take a payment today, take a payment tomorrow, and apply for Medicaid on Thursday, and you're okay.
Now, as far as taking out, a Roth doesn't have a required minimum distribution the way a simple does, right?
That's correct, but math is math. So what you would do is talk to your financial advisor or do it yourself. You can go online and calculate what the required minimum distribution is based on your age and the principal balance of the retirement account. The Roth does not have to come out, but if you don't take it out, they're going to count it as a resource. So if you have $150,000 in a Roth IRA and you just let it sit there, they're going to look at that as $150,000. If you have a $150,000 Roth IRA and you're taking $450 a month out of there, they're going to say, all right, we want to talk to you about that income, but we're going to let you leave that $150,000 resource. In order for it to be treated like a traditional IRA, you got to treat it like a traditional IRA.
So you could even essentially take out a very small amount and have it counted.
You got to take out at least what the RMD would be if it were a traditional IRA. You can't just take $1 a year out. You've got to pretend that it's a regular traditional IRA and calculate it based on that.
Russ?
Yes.
Yeah, I just went through this with my broker too. In our situation, I'm 17 years younger than my wife. So there's a different formula for how much you have to take out every year. It's based on, there's such a wide division in our ages. And are you familiar with that at all?
Yeah. But at the end of the day, if it's your wife's IRA, you have to calculate the income distribution based on her age. And if it's your IRA, you base it on your age. Now, the interesting thing about that, I've had clients, I can think of one client, he was 78, so he had been taking money out of his IRA for a while. His wife was 62. When he died, she inherited the IRA. She didn't have to take it out for another 8 years. But that was outside of a Medicaid situation. IRAs are a very unique creature, and the government has not really figured out how to treat them. Even though they created them, They had proposed regulations for about 18 years with IRAs that were, we'll probably treat it like this. But the rules behind an IRA are complicated enough that you want to talk with a financial advisor that knows what they're talking about when they talk about Medicaid planning and IRAs, and you want to talk with an elder law attorney that knows what they're talking about. If you have an IRA and you don't want them to count it, you got to take it out based on your age. And if your spouse has an IRA, you got to take it out based on her age. And obviously, the older you are, the higher percentage you've got to take out annually. Medicaid is going to say, we don't want you to take it out annually. Figure out what the annual amount is and then divide that by 12 and take it out every month. I invented a word. I call that monthalizing. Okay, so you monthalize the IRA. Anything else? Linda, you're shaking your head at me.
Russ, you might want to share with these folks what you did with me on a will, and that is giving specific gifts in a will rather than giving them while you're still alive.
I've done a lot of different things, and it's going to depend pretty much on specific wishes. When we talk about gifting, there are a lot of different kinds of gifts. I want my son to get my pocket knife. So I'm either going to put in my will, I want my son to have my pocket knife, or I'm going to tell my wife when I die, give my son my pocket knife, or I'm going to give it to him while I'm still alive. Another thing that I talk about, and Pat, when I totally forget what you want me to say, come back and
Well,
call me up. But
yeah, it was just what you're talking about.
Another thing that I will say to clients is they'll come into me and say, all right, I want to give $5,000 to my church, $5,000 to my college, $5,000 to my high school, and $5,000 to the such and such a charity. And I say, that's great. What happens if you've only got $25,000 in your name when you die? So a lot of times what I will do with clients regarding gifting in a will is I will say, let's figure out what you want to give to your church right now. Then let's figure out what percent of your estate that is right now. So let's say you want to give $5,000 to your church, and that's 1% of what your estate is right now. I will frequently say, all right, we're going to draft it like this. I want to give $5,000 or 1% of my estate to my church, whichever amount is less. Okay. And that covers the depreciating value of an estate. So like I said, if you've got, $500,000 in your estate right now and you want to give $5,000, hey, that's pretty cool. But if you only had $5,000, you don't want to give all $5,000 to your church. We can accommodate that. There are, God, Pat, that's such an open-ended question. There are some reasons why I may want you to give a gift through your will as opposed to giving it while you're alive. If I had 1,000 shares of Paycheck stock that I bought in 1988 for $2.50 a share, and now that stock has split and it's 10,000 shares at $100 a share, if I give it to my son today, his basis is going to be equal to my basis. And if he sells it, he's going to have a huge capital gain. If I die and let it go through my will, then he gets a step up basis, meaning his basis is the value of the stock on the day that I die. So he doesn't have to pay as much capital gain. Sometimes I will say, don't give it away now because you need it. You never know what you're going to need. You may want to give $10,000 to all these different people, and then you get done divvying out the cash and you look around and there's nothing left for you. So you want to make sure, that you take that into consideration. Now, having said that, there is an expression that we use in this business sometimes called giving the gift with a warm hand. It's nice at times to see the thanks in their eyes when you have given a gift to someone, or it's heartbreaking when they look right through you and don't acknowledge your kindness, but hopefully that's not the situation. And there can be situations where you want to give it to them now. There can be situations where you want to give it to them now so that we can start avoiding a 5-year look back period. There can be situations when you make a gift to your church, you say, I'm giving money to my church so they can put a new roof on the church, okay? Then 3 years after you draft your will, they put a new roof on the church, and it's one of those fancy 50-year roofs. They don't need another roof. 10 years later you die and they don't have enough money to keep the lights on, and you've left them $50,000 that they can't use except to put a new roof on the church that they don't need because they put a new roof on 15 years ago. So when I talk with clients about making charitable gifts, we want to talk about, do you make that a restricted or a non-restricted gift? Do you give the the governing entity the ability, the authority to use it as they see fit? Or I'm going to give $5,000 to this group and they're run by so many schmucks, I don't want them to have any discretion. This is what they got to do. And we can set it up many different ways. And that's something that, I think you want to sit and talk with a lawyer about. That's not go download a LegalZoom.com will and fill it out. If you've got some gifting intent, let's talk about it. Let's talk about the advantages to it. Let's talk about the disadvantages to it. Do you want to make a list? A lot of times I'll have a client make a list that says, Alex gets my pocket knife, my daughter gets my dancing shoes, and my cousin gets my bicycle. Great. And if they get it, cool. And if they don't get it, that's too bad. Maybe I don't have that bicycle anymore. Maybe I've hung up my dancing shoes. But I will talk with you about the many different benefits and disadvantages to making lifetime gifts and making testamentary gifts, which are, after your death through a will. Or let's cut the middleman out. And if you've got an IRA that you want to go to your son, make your son the beneficiary of the IRA. Don't wait until you die and run it through your estate, because then your estate will have to pay tax on it. And then the net number goes to your son instead of the gross number, and all sorts of different reasons. So different reasons to make gifts, and not all gifts are made for the same reason. Not all reasons will result in the same nature of the gift. I want that kid to say thank you while I'm alive. I want to hear it. Give it to him while you're alive. I might need it. I want to give them a step up in basis. I'll hold on to it and let them get it through my estate. How's that, Pat?
That sounds good.
Russ, and when I was doing my taxes this year, I ran across something I believe it's called a charitable distribution, where you can have your part of your minimum required distribution given to a charity, and it becomes a non-taxable event for you. Is that something that would help in a situation where now that I know that I have to include my supposed income from my Roth, where it would cut down my tax liability situation?
There's a lot of different reasons to do something. One of the reasons is a tax reason. And the IRS, they've got their own set of rules. The IRS says, as far as they're concerned, you can give $15,000 to as many different people as you want without any negative consequence whatsoever. Another set of rules are the Medicaid rules. And the Medicaid rules say, you give away $15,000 to 15 different people, we've got a big problem with that. So when you ask a question like that, there are different answers depending on what your question really is. And if the question is, do I want to make a charitable gift so that it helps my Medicaid eligibility? Essentially, I've got to say no. That's not really going to help. If you're making medical payments, if you're paying a nursing home, if you're you have a medical related payment coming out of your Roth or your traditional IRA or an annuity or an investment account, well, in a situation like that, you're very likely going to have a corresponding income deduction for the medical expense. As long as it exceeds a certain amount of your adjusted gross income, medical expenses are deductible. So taxes are not going to be a big problem there. If you're looking at trying to make a gift so that you can reduce your tax burden, you got to be careful about how it impacts your Medicaid, because you can't say to Medicaid, oh, the $100,000 I've given away every year for the last 5 years has been to, my church. And they say, then ask your church if they'll take care of you in a nursing home for the next 5 years. it's not always a be all end all, absolute positive. This is the answer no matter what kind of thing. But you can't let the
It sounded
Medicaid
too
fail.
simple.
It's not that, and if it's a tax issue, you got to ask your tax person. If it's a Medicaid issue, you ask me because Medicaid is my bag. If it's an estate planning issue, it's something I can help you with. If it's maybe a little bit of both, then I'll sit down with your tax person and your investment person and you and all those different kinds of things. There's no easy answers, which essentially is job security, and that's why I went into this. One of the reasons I went into this profession, because I'm always going to be able to help people with all these different things. What else, guys?
Thank you.
Well, thank you very much. And we'll seriously contemplate hearing you talk about trusts at some time in the future.
Sounds good. Thank you, Russ.
Thanks, guys. Thanks, everybody.
Thanks so much, Russ.
Thank you.
Thank you, Russ.
See you in a week.